All right, looks like we've got everybody here. We are live on YouTube on this discovery issue. Um, I have read the motion. I've read the back and forth emails. Before we talk about anything related to the merits, I want to see if we can accomplish something practical. So, Ms. Baer, I think you have said more than once recently that all you want is a shareholders meeting.
Yep.
And I have responded that there are more claims in this action than a shareholder meeting. So the question is, do you wish to proceed on any of those other claims? Because if you don't wish to proceed on any of those other claims, then I'm going to dismiss them and it's going to make this case a lot easier.
Your Honor, with all respect, as I'm sure I'm going to state the obvious, I'm the least informed person in this situation. Oh, it's strange. My video link changed, and Judge, you're in a tiny box now. Is that intentional? Like you're just in a little tiny box on my screen, and Erica's like the full screen, so it makes it hard for me to see you. The attorneys brought the claim. I never know what's privileged, but I hired them to cause a shareholder meeting. That's it. And I hired them alone without Bill Quirk or anyone else. And I only paid the bill, only me. So the lawyers put that other stuff in. I have to imagine it's for a reason. Perhaps they need it to support the other claim, and I am prepared to defend it. I mean, I understand based on what they brought those claims. I do think.
So let me get back and see if I can focus you on my direct question.
I don't know.
If there are other claims besides the shareholder meeting, those claims require evidence. You haven't done any discovery on those claims. So if you force the defendants to defend this claim, have to file a motion to dismiss it, and you don't have any evidence, then I can consider that an unnecessary expense on defendants and consider sanctions against you. Now, I don't want to do that. I don't know what evidence you have or don't have, but we're fighting over discovery right now. And if you don't have anything to support the claim, now's the time to say it and drop the claim so Mr. Wedekind doesn't have to go through the trouble of briefing these claims and telling me why these claims should be dismissed, and I don't have to go through the trouble of reading briefs and writing an order on it.
I gave them all the evidence in discovery.
Ms. Baer, you're not responding to my question. I have to be direct, and we have to get to it.
No, I do not want to dismiss them unless you tell me I have to, because I think the way the lawyers wrote it, I need to leave them there. All I want's a meeting.
Do you have any evidence to support those claims?
Yes, all the evidence that was part of the claim, the 8K filings that say everything they did and nothing else. I have no new discovery. They've not given me any documents, but
so the evidence you're relying on to support all of your claims in this lawsuit is the 8K filing. Now you recognize that they're going to file a motion to dismiss, and you're going to have to give a response that factually and legally can support your claims, your other claims, to go to trial.
I think I can I thought the claim did have the evidence in it. So yes, I can use the exact same things that were noted in the complaint as support.
Those are allegations, but you're going to have to bring factual, admissible evidence at summary judgment or a trial. You understand that?
Yes.
All right. So with that being said, hold on 1 second. Let me get myself some more light. All right. So with that being said, first let's talk about the discovery responses. Given Ms. Baer's disclosure today, I think she's disclosed what evidence she has in the case, and that you have that filing available to you. So I'm not going to find that she hasn't fully responded to the document requests. As to the deposition, your deposition is going to have to be taken. And so what we're going to do is we're going to set a date here today. We're going to set a date and a time. And if for any reason, Ms. Baer, you do not attend that deposition and sit for the entire length of that deposition, your case is going to be dismissed. Do you understand?
Yes.
All right. So let's talk about dates in the next 2 weeks. Date and time.
Okay, I gave you the dates. Let's see. Monday, I have. and I just-
Don't tell me what you have. Tell me what date that you can sit. Mr. Wedekind, how long do you think you need for deposition?
I would like the full day. I hope I don't go that long. But we've got a lot of ground to cover given that all of the claims remain in play. So.
All right, so we're going to need 2 blocks of 4 hours.
Okay. April 1st is a Thursday. This
April.
Thursday. Right, that's a week from today. It's wide
Does
open.
April 1st work for you, Mr. Wedekind?
I think
And
it's appropriate
tomorrow.
that it's on April 1st. Yes, we are available on that day.
All right, April 1st from 10 a.m. to 2 p.m.
10 a.m. Okay.
And-
10 a.m.
And
Eastern.
those are Eastern times, Your Honor?
Eastern time, yes.
And I'm
Well, that would make
available.
it, where are you? You're on the West Coast, Ms. Baer?
It's 7 a.m. my time.
All right, let's change it to noon to 4.
You know, I can do 7.
You want to do it early?
Yeah, no doctor ever makes an appointment at 7 in the morning.
All right, so we'll keep it early. 10 a.m. to 2 p.m. Eastern time. And then the next 4 hours block.
Well, the first 4 hours is I'm available tomorrow, all day. There's nothing scheduled at all.
All right, that sounds like that's too quick for Mr. Wedekind.
Okay, he can tell me and let me see what.
The Friday after the 1st, so April 2nd, I'm open.
April 2nd is we see the oncologist.
The day before the 1st, the 31st, I'm also available.
I'm available that day.
All right, so March 31st.
Same times?
That works for me.
All right, 10 a.m. to 2 p.m.
Okay.
And Your Honor, if we are able to complete the deposition on the 31st, we'll just cancel the remaining time on the 1st.
All right. Mr. Wedekind, I'm reserving on your motion for sanctions, but I will grant it if she if she doesn't appear and fully participate in the deposition.
Understood, Your Honor. If I might inquire of the court's ruling today.
Yes.
One question that I have is Ms. Baer's response to our request for production essentially said what she said today, which is all of my evidence is in HDC's SEC filings. I understood the court to specifically focus Ms. Baer on only those filings that are referenced in the allegations of the complaint. Is that right?
That's how I understand it.
And so there are no emails, there are no text messages, there are no letters, there are no posts on stock trading message boards, no other documents exist, because those would be responsive to our request for production.
Is that a correct statement, Ms. Baer?
Part of it is my response to them also was very specific as to which AK did reply to which response, because the lawyers identified it in the claim, but that's all I rely on. I never saved emails. Have I looked at message boards? Yes, but what's on a message board is irrelevant to the law. So I wouldn't even.
The real question is, have you posted anything on a message board relating to the claim?
No, and the only person I know of who did was a person by the name of Paul Bechtold, because he identified himself and said. So I don't even know any of the posters. I personally don't know Paul Bechtold. He identified himself to me and posted on the message boards as MB Money.
I guess the concern, Your Honor, is the different understandings of the scope of discovery. So my concern is I'm asking for documents that are broader than the documents that Ms. Baer believes that she relies on for her claims. I'm entitled to discovery to support our defenses of those claims, which is much broader. And so if I'm asking for those documents and she's saying, well, I'm only relying on these documents, we're ships crossing in the night, so to speak.
Well, frankly, at this point, I mean, frankly, I think it's overkill. I think we've all got a clear understanding of what she's relying on. And I think you've already got a clear understanding of how you're going to defend it. So yes, under the rules, technically you are entitled to more. But when I look at prejudice to you from not requiring it, I don't see any prejudice to you by me not requiring her to specify more.
I asked 5 questions that never were answered. When I first filed the lawsuit, the attorneys set up appointment to meet at the corporate office for inspection of records. They gave them the addresses of shareholders and none of the reports of the meetings or any of that. I'm trying to not make it bigger than it needs to be. If I was a lawyer and wanted to go into it, I'd say, well, I need actual minutes from all of their meetings. I do believe they supplied me some select ones in the notebook they sent me, but I have not gone through it. Can I ask them to be responsive to my request for production that the lawyers made?
You've won on that point. So you don't have to argue it anymore. I'm not requiring you to produce any additional documents. My requirement is that you appear for your deposition.
Yes, and I will, barring the worst type of an emergency.
But you understand, even the worst type of emergency, this is it.
Okay. Then you'll be okay if it's bedside in a hospital.
Wherever you have to be to get it done. We've had plenty of time to get this done, and it just hasn't happened, which is why I've scheduled it here on Zoom, live on YouTube, where the whole world knows either you put up then or you're done.
And can I make a request of the Health Discovery Corporation to provide the documents that they haven't been responsive to?
I think that their response is sufficient. So I'm
Okay.
not requiring them to produce any more documents. I'm not requiring you to produce any more.
Okay,
I think it's evenly balanced, and I don't see any prejudice to either side by not requiring either side to produce more.
okay.
Your Honor, if I may, I just want to confirm that we've been talking about the SEC and the 8K, and she has specifically identified the 8K that was mentioned in the complaint. Want to make sure when we do have to file our motion for summary judgment on the remaining claims, that she's not going to be allowed to introduce any other evidence other than her own deposition testimony and that reference to that 8K.
That's my purpose of trying to figure out what the universe is. And my understanding, it's only the documents referenced in the complaint. And anything else, if anything else pops up, some surprise document, it will be precluded as a discovery sanction.
Am I supposed to supply documents that occurred between my attorneys and their attorneys? I always thought that stuff was privileged. I'll look, I don't have stuff, but I'll make anything
Well,
else.
you know, what the attorneys say to each other is not going to be evidence.
Okay,
So that's,
okay,
you know, that's not really material.
okay.
All right, does everybody have their marching orders going forward?
Yes,
Yes, Your Honor. So we will notice those two deposition dates today. Do we need to prepare an order for the court memorializing your rulings?
I think it's best that we have an order specifically referencing the consequences.
and I'll do it first. You'll write it, Mr. Wedekind.
I will
Yes,
draft
and
it.
he will copy you on it when he sends it to Mr. Townsend. If you have any issues, then you can address those with Mr. Townsend.
Okay,
All right.
yes.
We'll do it, Your Honor.
All right. Thank you, everybody.
All right.